All right, thank you all. My name is Chip Lupu. I'll be the moderator for this panel. I have 3 jobs. Briefly introduce all 4 speakers, who will then each speak for about 15 minutes or a little bit less in the order in which I've introduced them. Then we'll have time for questions and responses. So I'm going to introduce, I'm going to monitor their time, and my 3rd job is to make sure you all look alive. So whether or not you are alive, I'm going to be paying attention to who is looking alive, and I will call you out if I see you nodding or leaning back or checking your phone. So just so you're mindful of that, okay? Thank you all. Douglas Laycock is the Robert E. Scott Distinguished Professor of Law and Professor of Religious Studies at the University of Virginia. In prolific scholarly writings, legislative testimony, and briefs to the Supreme Court, he has defended a vision of liberty for both sides in America's culture wars. Chai Feldblum is a commissioner on the Equal Employment Opportunity Commission and a former professor of law at Georgetown University Law Center. She has written several articles exploring the relationship between gay rights, religion, and morality, beginning with a 1996 article titled Sexual Orientation, Morality, and the Law, Devlin Revisited. Stephen Smith, at the far end, is a Warren Distinguished Professor of Law at the University of San Diego. He is the author of a number of books and articles on religious freedom, including The Rise and Decline of American Religious Freedom, Harvard Press, 2014. Mary Ann Case is the Arnold I. Schur Professor of Law at the University of Chicago. She is widely published on legal issues related to gender and sexuality. She is engaged in a project on feminist fundamentalism, including current work on Vatican opposition to what it calls the gender agenda. This is an extremely distinguished panel. We're going to start with Professor Laycock and move on in the order in which I've introduced people.
Thank you, Chip. A couple of preliminary matters. I'm in the same situation as Andy Koppelman. I have to leave in the morning for another deadline, so I apologize to tomorrow's panelists. You can beat up on me tonight. I do have a paper that I'm not going to talk about much. It's called Religious Liberty and the Culture Wars. It's up on SSRN. It's coming out in Illinois. It was the Baum lecture there. It's way too long for 14 minutes. And there is an earlier, much more conceptual, much less detailed version of it that some people like the title of, called Sex, Atheism, and Religious Liberty. I shouldn't have to say this, but I think that I do, given the tone of many of these debates, and we've, to some extent, avoided it here. We have certainly not entirely avoided it. I am a non-believer, fully secularized, large D Democrat, civil libertarian, right? And I really do believe in defending the liberties of both sides, and I got a handful of allies, but it's very lonely here in the middle. At the core of the problem we are dealing with many of these issues is that neither side has any desire to protect the liberties of the other side. As Kenji said earlier today, they really just wish the other side would disappear and go away. The difference is the religious conservatives, most of them, there's still some true believers out there, but most of them understand they're losing. The other side isn't going to roll up and go away. Many of the folks on the left believe the goal is achievable. They can make these people disappear, and that comes through in much of what they say. So I very much endorse Nan Hunter's comments this morning about avoiding demonization. We would help the tone of debate a lot if we could do that. If we could avoid the contempt and ridicule that we often hear. Heard a lot of it last night, and if you didn't hear it, you weren't listening very carefully. Contempt and ridicule as we describe the other side's arguments. The cartoon that Caroline Corbin mentioned today was one panel in that cartoon that runs on the editorial section of the Sunday Times, about page 3. It was a series of panels ridiculing Hobby Lobby in various ways of a sort that neither the Times nor the Wall Street Journal would ever have run about gays since 2006, say. There is a lot of contempt and ridicule and hostility, and certainly there are plenty of bigots over on the religious right. there are fewer and fewer of them, and they're not out in public, right? They understand they have to go silent. And they're not among the educated classes. My emails come from academics and educated folks, and some of them are pretty hateful. I'll just leave it at that. And I'm sure I'm not the only one. So Kai Feldblum, sitting to my right, a few years ago in a book I edited, said, well, I really can't think of a single case in which the religious side ought to win, but we should respect the burden we're imposing on them. We should have some angst about it before they lose. And she was intensely criticized by both sides. We shouldn't have any angst about it. We shouldn't respect them. She was condemned as soft on the issue. She also got it from the religious right. She got it from both sides. But I think we need to take seriously how intensely important these issues are to the people on both sides and look for ways to let each side live their life by their own values. Now, part of the issue here is the two sides have radically different understandings of how RFRA works. Because one side has been in the trenches for 20 years, and the other side only started paying attention when the contraception cases and Elaine photography came along. RFRAs have been under-enforced. People struggle to win any cases at all. Chip Lupu did an article back in the 90s about the federal RFRA. Chris Lund at Wayne State has done a more recent article about the state RFRAs. Judges are extremely quick to find compelling interest and extremely slow to find a substantial burden on religious exercise, which doesn't mean that there haven't been some wins. There have, but it is very difficult to win these cases. Substantial burden has certainly not been a blank check. The compelling interest test, I think, has often been misunderstood. People look to the race cases and to some extent to the speech cases and say compelling interest, I think Justice Kagan said, is the most difficult standard known to the law. Strict in theory, fatal in fact. You can never show a compelling interest. Well, as the court says, it depends on context. There is hardly any good reason for discriminating on the basis of race, so in the context of race discrimination, it's almost impossible to show a compelling interest. There are very, very few good reasons for telling people they can't say something, and most of the ones that there are have been reduced to specific doctrines, like Brandenburg. So there aren't many. It's hard to show a compelling interest there. But the compelling interest test as applied to religious conduct, there are many more good reasons for regulating conduct. Conduct can hurt people. Conduct can blow stuff up. So just because the standard is stringent doesn't mean it's impossible to show. And in practice, it has been, in my view, way, way too easy to show. So the supporters of RFRA keep trying to beef them up, keep trying to make them stronger. So the second generation of state RFRAs, the ones enacted after Bernie in 1997, typically have a definition of religious exercise that says doesn't have to be compulsory, it doesn't have to be central, any religious exercise counts, or the better drafted versions say if it's substantially motivated by religion, it counts as religious exercise. Version of that got written into the federal RFRA by the Religious Land Use and Institutionalized Persons Act. Those amendments have helped some. They haven't created a radical change in the level of enforcement. They have been nullified in some states. So this example is, out there on the edge. It's not that every court is doing this, but it's indicative of the problem. The Supreme Court of Florida took the Florida RFRA in a case where Boca Raton wanted to take all the crosses and statues of saints and stars of David and Jewish grave coverings out of the city cemetery. And the city's theory was there's no burden on religious exercise here because your religion doesn't require you to do this. They put on an expert on Christianity who said if it's not written in Scripture or if it hasn't been practiced universally throughout time and space, it's not part of Christianity. That was the good guy. They put an expert on Judaism who said, I'm not making this up, he says, most of the religious stuff you see in the world is folk religion. It's run by women. It doesn't count. It has to come from authoritative theological sources, and those will mostly be men. And if it's not written down in the law somewhere, it doesn't count. And the district judge bought all this, adopted all that testimony. The Supreme Court of Florida said, well, we see in the statute it doesn't have to be compulsory. Got that. Okay, so this is religious exercise, period, paragraph. But the burden isn't substantial unless it is compulsory. So only compulsory activity is protected by the Florida RFRA. It has been very difficult to win these cases. The opponents see this juggernaut of wins in the contraception cases and think, gee, this statute is an engine of destruction. It's going to override everything. Well, it doesn't, and it won't, even if Hobby Lobby wins. The juggernaut has happened for a variety of reasons, I think, some legitimate, maybe some not so much. I can't tell you how much of it is hostility to the president and to the Affordable Care Act, but it's not only conservative judges who are doing it. It's also moderate judges. It's some Democratic judges. I think, as Marty Lederman alluded to a couple times this morning, the compelling interest test is a matter of weighing the government's interest against the religious interest with a heavy thumb on the scale of the religious interest. The government interest has to compellingly outweigh the religious interest, but it is ultimately a balancing test. The weight of the religious claim counts, and we don't have claims like this before. This is the one part of what Reva Siegel and Doug Nejame were saying today that I agree with. All religious liberty claims are anomalous by definition. You don't have a religious liberty claim until you lost, until the majoritarian political process says you're wrong, we're right, the law is going to be our way, okay? So the Catholic belief that contraception is wrong is deeply anomalous. Hardly anyone agrees with it except the bishops and a small percentage of Catholics. The Hobby Lobby belief that life begins at fertilization, and we take that so literally that a morning after pill is an abortion, or it might be an abortion, as the FDA label says. It might act by preventing implantation. That's a deeply anomalous belief. Not many people believe that. But what is different about these two beliefs, okay? The contraception teaching is a very well-known, distinctive teaching of the largest church in the country. We haven't regulated things like that in the past, okay? It was handled politically. Large churches didn't need religious liberty statutes because they didn't get regulated. And one of the arguments for protecting religious minorities with exemptions was it gave minority churches the same kind of protection that the big churches got from the political process. The belief that life begins at fertilization is shared by churches that represent nearly half the population, a quarter of the population Catholic, a quarter of the population evangelical. We haven't made their practices illegal before. That matters to judges. There's absolutely no doubt about sincerity in these cases. Judges don't talk about sincerity, but it matters deeply to them. If there's a whiff of insincerity about your case, you lose. And the doctrine may be something else. They may say no burden. They may say compelling interest. But the one thing we know for sure they will say is you lose. And there's no doubt about sincerity in these cases. There's no doubt about the weight of the claim, the intensity with which it is held, and that goes to the striking of the balance. There's clearly a substantial interest in these cases. Let me say just a little bit about a substantial burden in these cases, and it affects the application of the compelling interest test. Let me say just a little bit about the claims for exemption in the marriage cases, as same-sex marriage cases. There's a lot of loose talk about people who don't want to serve gays. There are no cases. There's one reported case, 1985, Supreme Court of Minnesota, the religious claimant lost, right? The people who say, I can't deal with gays, I can't have a relationship with gays, I can't serve them, they mostly don't exist anymore, and the ones who do can't find lawyers. No one's bringing those claims, okay? The claims that get brought are in particular context of greater religious significance. It's about the wedding itself. It's about relationship counseling. So we got these cases of graduate students being kicked out because they won't counsel gay couples. The last thing in the world a gay couple with a problem wants is to be counseled by some conservative Christian, right? It's not good for either side to say they don't get an exemption. It's just we win, you lose. It's turf pounding, but it's not designed to help anybody. So we have, as Marty Lederman said, only a handful of cases, but they are all about the wedding itself or a wedding substitute like a commitment ceremony, or the landlord cases are about the sexual relationship itself, about providing the bedroom. And complicity is not something these people made up. Complicity is something that goes back for a very long time theologically. It's very important to progressive politics. If you think about the boycotts of South Africa, how complicit did a company have to be before they should be boycotted? Both sides want to avoid participating in what they believe is wrong or evil. Nothing new about these claims. My own view is both sides need some space to live their lives. The churches and the religious organizations themselves should be exempt, period, full stop, unless they acquire a monopoly. So a Catholic hospital can't take over all the hospitals in town and then claim we still get to act on Catholic principles. And the very small businesses, the places where the owner has to perform the services herself, like Elaine Photography, ought to be exempt. Bigger businesses aren't making claims and shouldn't win if they do, in my view.
Okay, so number one, as an accommodation to everyone sitting in the back few rows, which is where I was sitting, I'm going to be standing. And I love the fact that the mic is actually for people my height. So first of all, the expected disclaimer you might imagine. I am speaking here as an individual commissioner of the EEOC. I am not speaking on behalf of the EEOC. The EEOC did put out some pretty extensive guidance on discrimination on the basis of religion in 2008, and I will reference some of that as I go through. But I have an additional disclaimer, which is I may not even be speaking for myself. And what I mean by that is I am taking the opportunity of this academic conference to engage in musings on this topic with the goal toward greater understanding. I have no idea if any legal idea or thought I might say today will in fact be a legal position I hold at some future time. Okay, so that's very important. I mean, one of the nice things about being an academic is if you're not sure where you want to land, at the end of your article you say, tough question, next article. And that's not the case as a commissioner. You ultimately have to vote. You vote on cases, you vote on guidance. So please treat this as like an oral argument. I may be saying certain things that does not mean that's where I will end up being. Okay, so the first thing, of course, is to note that this is not a new issue for many of us in this room. I do think that it's a very positive thing that this type of conference has been put together. And I do want to commend not only Harvard Law and Nomi from USC, but also, and ACLU, but also the Williams Institute that did in fact start conferences. This is the third that they have sponsored of this kind, and I think each of them has been helpful. So as I said, not a new issue. I actually, while Kenji was talking, I pulled up an article that I wrote in 2002 called Rectifying the Tilt, Equality Lessons from Religion, Disability, Sexual Orientation, and Transgender. Now, the main focus of that article was to explain how reasonable accommodation, which might seem like equality plus, some special right you were doing for someone, was really equality minus. Because you were dealing with the situation where a background social norm was disadvantaging some individuals. So in order to sort of recalibrate, they were like on a tilt, to recalibrate, you were doing an accommodation just under them. And I explained that actually the EEOC created this concept for religious people, right? Title VII just said you can't discriminate based on religion, and the EEOC realized as cases came before it, private charges, if we just treat everyone the same, we're not actually treating them equally, because they're not the same to begin with. So if you have a social norm that presumes you can work on Friday night, but you have an Orthodox Jew who can't, maybe we need to make an accommodation. And so one of the things I said there is, right, is equality is not treating people equally the same, it's treating people as equals, with equal dignity and respect, with everything that they come with their differences. And then I noticed that section E of the article, which has like 3 paragraphs, just says, now, wonder what happens when you rectify the tilt under one group, and then that puts another group on a tilt. Like, what do you do then? And the example I used was civil rights laws prohibiting discrimination against LGBT people. Because the idea was it was about shifting in social norms about morality. So none of this is new now to, given what we've heard today, but just to capture sort of my thoughts on this. As many of you may know, most of my academic writing has been around this moral values, gay rights issue. And I started something called the Moral Values Project. I started that after the 2004 election. And it was basically just a website and a few ideas. Okay? So the few ideas are, first, a person's sexual orientation, whatever it is, or a person's gender identity, is morally neutral. It has no moral valence, no more moral valence than the color of your eyes. Second, a person acting in accordance with his or her sexual orientation or with his or her gender identity is morally good. That is, such activities have a moral valence, indeed a positive moral valence. And third, as a strategic political matter, we should make these substantive moral arguments, that sexual orientation and gender identity are morally neutral, that acting on one's sexual orientation or gender identity is morally good. We should actually make those arguments around the kitchen table and in the political realm, because that was the only way we were really going to achieve true equality for LGBT people. Why? Because I'd been convinced by writings of Michael Sandel, Robin West, etc. You might think that liberal neutrality is the way we run government, right? Government does not choose between competing conceptions of the good. And I don't know, that didn't line up with what I saw going on in politics. Seems like people were always legislating based on what they thought was the right thing to do. And I just felt as a practical matter, it's pretty much what Rick Garnett said, right? It's not true that discrimination is always wrong. We make distinctions all the time. It's wrongful discrimination that is wrong. And I was like, right. So, when the public says it's an American value not to discriminate, what they really mean is we shouldn't discriminate against people who are similarly situated. But if the public believes that gay people and straight people are not similarly situated, right? For example, there's something morally wrong in loving someone of the same sex, then it doesn't seem like wrong discrimination to treat gay people differently. However, and so again, whether you believe liberal neutrality is actually not a correct political theory, which is where I am, or whether you think it just doesn't control, either way, I felt that we had to change the public's underlying moral assessment of sexual orientation so that the majority no longer believed that a gay sexual orientation was morally problematic. Once they felt that, then suddenly a gay and a straight person would seem to be much more similarly situated. And then, oh my God, suddenly it's like that must be discrimination because we're treating them differently. And they're the same. So that was my primary goal in trying to deploy moral values discourse. But there was always a second goal, and it's the one that's really been at play in this conference, which is the reality of what happens once society actually shifts its social norm in that way, and it starts to pass laws that says you may not discriminate based on sexual orientation or gender identity. What does that do for individual religious people and for religious institutions who are still holding on to a different moral view? That is, that sexual orientation, or certainly acting on your sexual orientation, is not morally neutral. And Doug, I've heard various times that I've said, I can't think of a case in which the religious person will win. Thank you for reminding me. I was like, what? They must have made that one up. Just like they made up the sentence that I've said, gays win, Christians lose, which, by the way, I have never said. And I've explained that I've never said that. Not that that stopped quotations. But in any event, I think what that must have been, and you'll see here, I do believe there are certain situations in terms of a business operating in the commercial space where I can't see that there should be an accommodation. That's definitely true in that slice. So I don't agree with Andy Koppelman that actually we could just take care of, the Elaine photography without causing some of the citizenship problems that have been discussed. So yes, in that realm. But that doesn't mean that that's the case in all realms. So now let me just move to employment in 5 minutes. Okay. Is that right? Good. So under Title VII, individuals have a right not to be discriminated against on the basis of religion, and they have the right to ask for a reasonable accommodation because of their religious beliefs or practices, so long as that accommodation doesn't impose an undue hardship. Okay, that's for the individual. In that context, there is a discussion of the sincerity of beliefs in the context of, do you have a religious belief that needs to be accommodated? And actually, it's very broad. I mean, it doesn't even have to be any religion. It's like if it holds a space in your life that is akin to a belief in God, that can be a religious belief under the Title VII. And I have to say, even with TWA versus Hardison, putting a very de minimis standard of undue hardship, EEOC has been a significant leader in protecting the religious liberty of folks in employment. And that's whether you want to wear a hijab or you have to wear a skirt as an Orthodox Jew, you can't wear pants. I mean, we've done a number of cases, and I think that absolutely aligns us, as we should, of religious liberty as part of civil rights. Absolutely. So that's one piece in terms of Title VII. The other piece of Title VII is the exception for religious institutions. I will tell you, I find the latter harder than the former in terms of thinking about now this next stage. Okay, so the next stage, as many of you may know, the EEOC ruled in 2012, April 2012, that all transgender people are covered under Title VII as a form of sex discrimination. We've had several other federal sector decisions explaining how gay people, if you discriminate against someone because they're gay, that is a form of taking sex into account. All investigators now know if a transgender person or a gay person walks into an EEOC office, says, I've been discriminated against because I'm gay or because I'm transgender, the investigator takes that case, codes it under sex discrimination. And we have 200 some charges currently in our offices around the country. So we're doing that because we believe that these are forms of sex discrimination. Well, obviously, then the next question becomes, what if someone now says, I have a religious belief of, I want to get accommodated so that I do not have to, either as an individual person working for a corporation that is now telling me not to discriminate, okay, and I feel like I do want to discriminate because of my personal religious beliefs, or I'm an individual who runs a business and I want to discriminate in terms of hiring. Well, I think, Doug, so I think to the extent that you think the question is whether the actual act of complying, okay, with the law is assisting in the performance of a, no, if you think it's about compelled speech, sending a message the person doesn't want to send, then I think Nan Hunter's point from this morning is right. You could just say that, look, we're just going to say compliance with the law does not presume endorsement. And that might actually work well. Actually, I don't think people see complying with the law as necessarily endorsement. But if the question is whether the actual act of complying with the law is assisting in the performance of a sin, right, this idea of making me morally complicit in sin, then the question is not whether complying with the law is sending a message of endorsement. The question is whether the person's religious belief is being burdened with this moral complicity. Now, Doug and Weaver may be correct at the end that you simply should resist the validity maybe of these morally complicit claims, just it's not fitting into the, you know, where we came from in terms of this. I have to say here, I am sure that my background growing up as an Orthodox Jew makes me more sympathetic and understanding how being forced to act in a certain way may feel like being made morally complicit. So My current feeling, I think, run more along the lines of what Michael Helfand stated this morning. That is, obviously, the law needs to look into the sincerity of the belief, which Title VII requires. I am uncomfortable with the idea of the law in the guise of either an agency official, an investigator, a commissioner, a judge, deciding whether the religious person is really burdened. I mean, again, some things that I know as an Orthodox Jew, you just had to do, and someone else would think like, oh, just get over it. And you just can't get over it. And so that, I agree with Helfand, that's precisely where I am uncomfortable with giving that over to the government, but I agree it is precisely the role of the government to decide whether something is either an undue hardship, as it is under Title VII, or this is good because this will make me stop. Whether it's undue hardship, or if we ended up with a RFRA challenge, whether it's advancing a compelling interest. So what I did not get to, but I want to state, there is protection for religious institutions in hiring people of their own religion. Now, last night, because of Amos, I described it as you could hire a good Mormon, right? Query whether that's really what the law requires, what the law allows. The law allows, says you can hire someone of your own religion. It happened to be for the Mormons, they had a system where you could have a certificate that told you if someone was a good Mormon and therefore a Mormon. For other religions that don't have that, I think it might be a different question.
The speakers have been excellent so far, and you are doing extremely well and looking alive. I've been paying attention. Thank you. Stephen.
Okay, well, it's an honor for me to be included on this distinguished panel, and I haven't spent much time here at Harvard, rarely been here, so for me it's more of a big deal than it is for probably a lot of people just to participate in a conference here. I sort of, then, more than some of you might think, a little bit about the history of the institution. I passed a building yesterday with the name Mather on it, and I wondered whether it might be appropriate to thank the Puritans for founding this university so that we can now gather and discuss whether and how to accommodate their somewhat diminished descendants. I prepared a draft paper for this panel, which tries to explain why religious conservatives like myself don't rush to embrace the live and let live compromise proposed by a group that I call the moderators. This would include Doug Laycock, Tom Berg, Alan Brownstein, Robin Wilson, and others. The specific proposal that they offer is to legalize same-sex marriage while making ample exemptions for religious objectors. And I say in the paper, sincerely, that I admire Doug and his associates for their excellent scholarship and also for their efforts to find common ground. For myself, if I thought their compromise could hold, and if I had the power to enact it, I would. But I'm skeptical about the viability of this compromise and of accommodation more generally, and my paper tries to explain why. The paper's too long to read in 14 minutes. I'm happy to share it with anyone who's interested. But for today, I've tried to cull some thoughts that bear on our topic and that hopefully won't duplicate too much of what's been said already. So let me start this way. Years ago, when I was beginning my academic career, I wrote a couple of articles on the theme of toleration, which seems to me very much akin to the accommodation we're talking about here. And a common reaction that I got was puzzlement. I remember one colleague in particular who was a libertarian saying, the odd thing about your article is that you talk as if toleration is something that has to be justified. But it seemed to her that toleration was sort of the easy, natural position, and that it's intolerance that takes some effort, and so has to be explained. Now, that's a common attitude, I think, but at least as a historical matter, and a psychological one, and possibly even a philosophical one, I think Holmes's famous remark is more cogent. Persecution for the expression of opinions seems to me perfectly logical. If you have no doubt of your premises or your power and want a certain result with all your heart, you naturally express your wishes in law and sweep away all opposition. In recent decades, at least, tolerance and toleration have usually been regarded in polite society as virtues, but it hasn't always been so. Tolerance has often been viewed as a sign of weakness or lack of commitment or conviction, and often with good reason. Even today, institutions proudly announce that they have a zero-tolerance policy with respect to various sorts of perceived evils. And proposals to include intelligent design in the public school curriculum, even in the gentlest way and on an equal time basis, don't evoke from the scientific or judicial establishment's celebrations of Holmes as open marketplace of ideas, but rather something closer to the old Catholic slogan, error has no rights. This sort of attitude of unapologetic intolerance may or may not be unfortunate, but it's neither illogical nor unnatural. In fact, I think it's a very real question. Can a true believer really be tolerant of or willingly accommodate ideas or practices that he's confident are wrong and false? Now, I think the answer to that question is yes, toleration is possible, but it isn't either easy or natural. It may require some justification from within the body of beliefs that the true believer adheres to, and it probably also requires the right set of conditions for that justification to be acted on. So on this understanding, we might ask what sort of toleration or willingness to accommodate we can realistically expect from the current parties in the culture wars. In reality, of course, those parties overlap a lot, and they include millions of people who differ significantly in various ways, including in their propensities to be tolerant. But for present purposes, I'll have to describe the parties in more simplified and monolithic terms, and to give only a shamelessly summary discussion of what I see as their proclivities for tolerance and intolerance. So first of all, the religious conservatives, who in this country are mostly Christians. Christianity is and always has been complex. As I've argued at length in a recent book, from the outset, Christianity contained motivations for a more intrusive intolerance than was typical in the ancient world. However, in its belief, taken from Hebrew scriptures, that all human beings are created by and in the image of God, and also in its belief that only a sincere and voluntary faith had spiritual value, Christianity also supported justifications for a more principled toleration, and these rationales were articulated from the earliest years. In the centuries after Constantine, though, it was the potential for intolerance that was conspicuous. The litany of instances of Christian intolerance are familiar enough even to people who know little else about Christianity, the Crusades, the Inquisitions, and so forth. In recent centuries, by contrast, as Christians have had to come to terms with pluralism, the rationales for toleration have become more prominent in Christian self-understanding. For Charlemagne or Alfred the Great, it seemed perfectly logical, as Holmes put it, to compel conquered foes to be baptized. For Western Christians today, the idea would be unthinkable, and the percentage of Christians in the West today who favor anything like a return to the confessional state is minuscule. Doug Laycock's recent and important articles on this subject shed some light on Christians' inclination for tolerance, albeit somewhat against his intentions, or at least against his rhetorical strategy. Doug tries to be symmetrical, I think, in casting each side in the culture wars, castigating each side for intransigence. He says that proponents of sexual equality insist on enforcing anti-discrimination laws against religiously scrupulous counselors, photographers, and others, even though these professional services or products are readily available elsewhere, and even when no sensible same-sex couple would actually want the assistance of, say, a counselor or photographer who's religiously opposed to their union. In such litigation, Doug suggests, the goal seems to be not to gain a needed remedy, but rather to punish opponents or to drive them out of business. But Christian conservatives are equally unyielding. They oppose measures such as same-sex marriage, even when these measures would leave the religious believers themselves free to marry according to their own beliefs and commitments. Quote, the religious side, Doug says, persists in trying to regulate other people's sex lives so long as it thinks it has any chance of success. Despite the appealing even-handedness of indicting each side, I think this last characterization is mostly mistaken, and I think Doug's own more detailed analysis persuasively contradicts this particular accusation. With respect to contraception, for example, Doug explains, correctly I think, that, quote, nearly all Americans think they are entitled to use contraception and that it is no one else's business. These nearly all Americans include the religious conservatives, like myself. Consequently, it's unimaginable, he says, that any American state would now attempt to ban contraception. Indeed, the bishops gave up that battle long ago. And a page or two before his accusation that I quoted above, Doug reports that although religious conservatives continue to oppose abortion and same-sex marriage, quote, every other form of non-commercial sexual behavior has been deregulated either de facto or de jure, and religious conservatives have mostly acquiesced. There is no significant lobbying, I'm still quoting, to enforce or reenact fornication laws, adultery laws, sodomy laws, or laws against gay and lesbian sex. No-fault divorce is much lamented, but there's no significant effort to roll it back. Even the effort to restrict pornography has largely collapsed with its energies redirected to child pornography. On all these issues, churches teach what people morally should do, but they no longer seek to control by law what people may do. So it seems that by and large, religious conservatives are not trying to regulate other people's sex lives. Indeed, that description seems subtly askew even in the area of abortion. As Doug knows and reports, Christian conservatives oppose abortion because they believe the practice takes the lives of innocent human beings. These conservatives are acting, as they suppose, to protect those lives. It's true, to be sure, that restrictions on abortion would have constraining effects on some people's sexual activity and decisions. Even so, it's misleading to declare that the conservatives are trying to regulate other people's sex lives, as if this were the purpose or objective of their anti-abortion efforts, just as it would be a distortion to say that environmentalists are trying to destroy jobs and force Americans into unemployment. Although some measures favored by environmentalists could foreseeably have such effects, that's surely not the goal or purpose of such restrictions. So much for the religious conservatives. Another party I might describe loosely and with apologies, but with genuine affection, as traditional mainstream liberals. Very briefly, I think this party also has the resources to justify tolerance. Maybe it's enough to cite John Stuart Mill here, and also considerable experience over the decades with the practice of tolerance or accommodation. Thus, Senator Kennedy and Senator Hatch could collaborate to sponsor the Religious Freedom Restoration Act, and thus Berg, Brownstein, and Laycock, all of whom I would place in the broad tent of mainstream liberalism, struggle valiantly to work out terms of accommodation. In recent years, though, it becomes increasingly apparent that the campaign for equality is being driven not solely or even primarily by traditional mainstream liberals, but rather by a movement we might call, for lack of a better term, the new egalitarianism. This movement is less pragmatic than traditional liberalism was. Instead, it exhibits a kind of self-confidence and almost religious zeal. Its non-pragmatic, quasi-religious quality may help explain, and perhaps excuse, the tendency of its proponents to oppose state RFRA-type laws by imagining hypothetical horribles or abuses without feeling the need to show that there's any actual likelihood that these horribles would occur often or at all. In other contexts, this sort of parade of horribles rhetoric is often thought to be an irresponsible form of argumentation. By contrast, though, in a philosophy paper or even a law school class, it's often perfectly acceptable to test the merits of a principle or theory against the most imaginative or exotic hypotheticals. In a similar way, I take it that the egalitarians' horribles are calculated to show that RFRA laws are somehow impure or immoral or wrong in principle, even if the horribles are unlikely to pose a significant real-world problem. The new egalitarianism seems to me a new thing in the world, or at least on the American scene, and that makes its propensities uncertain and hard to predict, and for people like me a bit frightening. It's true, of course, that equality has been a central theme in our politics from the beginning. But we also know, and for now I hope it's enough to incorporate by reference Peter Weston's famous article, that equality is an empty vessel. Its substantive content has to be poured into it from other sources. In the past, those sources have been, for the most part, some mix of biblical religion and what, with apologies, I'm calling mainstream liberalism and its antecedents. The new egalitarianism largely rejects and opposes at least the first of those sources, or at least it tries to. It's thus quite different from the equality of Jefferson, Lincoln, and the Reverend Dr. Martin Luther King Jr. Writing presciently a third of a century ago, the sociologist and political theorist Robert Nisbet observed the potential power of what he called the new equality. Nisbet argued that, quote, equality has a built-in revolutionary force lacking in such ideas as justice or liberty. Equality feeds on itself as no other single social value does. It is not long before it becomes more than a value. It takes on all the overtones of redemptiveness and becomes a religious rather than a secular idea. And he continued, it would be hard to exaggerate the potential spiritual dynamic that lies in the idea of equality at the present time. One would have to go back to certain other ages, such as Imperial Rome, in which Christianity was generated as a major historical force, or Western Europe of the Reformation, to find a theme endowed with as much unifying, mobilizing power, especially among intellectuals, as the idea of equality carries now. Now, given the novelty of the new egalitarianism, we search, as Nisbet does here, for imperfect historical analogies that might help us to understand it and to understand our situation in relation to it. In one of his recent articles, Doug tries to draw some parallels between the sexual revolution and the French Revolution. In my paper, I discuss, and Doug also has made, a parallel to the earlier French wars of religion. But as Nisbet suggests, maybe the most illuminating parallel is to the condition of Christianity after it became a newly ascendant power in the late Roman Empire. There are, of course, huge differences between Christianity and modern egalitarianism. For example, Christianity actually had a positive vision and account of the world and the good life. That was a vision that would lead to the founding of hospitals and universities like this one, and that contained, as I've suggested, the rationale for a more principled tolerance. Still, that theme remained pretty much submerged as Christians in their self-confident and righteous zeal exercised their newly acquired power against what they viewed as their longtime pagan oppressors. Insofar as the parallel holds, the lesson isn't reassuring for religious traditionalists today. It's possible, of course, that the new egalitarianism will somehow find within itself the resources for toleration. That's speculation, though, and recent developments don't give me much cause for optimism. And as with Christianity, it may take a long time for that possibility to emerge. At least in the short run, I still think we do have to explore the possibilities for accommodation and to cultivate toleration where that's possible. What else can we do? So once again, I admire Doug and the moderators for trying to do that, and I wish them success. But for the reasons I've tried to express here and others that I haven't tried to articulate, I don't have much confidence that accommodation will be the solution to our culture wars. Thank you.
Sorry, it's just going to take me a second. My computer died in there. Okay, so I am. I'm also delighted to be here and also delighted to honor the memory of the Puritans, the people who gave us civil marriage, who initially said that marriage was so clearly a civil institution that ministers not only could not perform, but could not attend the service. And I'm happy also to speak for their descendants, the religious congregations that were among the first in the country to promote and accept same-sex marriage. But what I'm here really to do is, I'm here in the second of these two Williams Institute meetings on these issues to say that everything that I was afraid of then has become true and worse. That was a meeting organized at Princeton with also Robbie George and his institute to deal with an attempt at compromise promoted by Andy Koppelman and George Dent at the time that they have, I think, as a result of what we all said, abandoned. And I came to that with normative concerns, but also a lot of descriptive concerns. And I want to, so I think that I'm in agreement with Steve that compromise here is simply not possible. I don't see a way to facilitate it. And at that point, asked people to consider some of the other potential analogies and whether compromise was possible then. One is religious establishment, whether from the cuius regio eius religio days or from the early days of the Republic. The other was Jim Crow, and please, I was not trying to say that people who support who oppose gay rights are racists. I was simply saying the practical the people who proposed Jim Crow practically were saying this is a way for two communities to live and let live. And I would ask if that, in fact, worked. And I think that the real analogy when we are talking about gay rights or the sexual agenda more broadly is the analogy to slavery, and that the nation cannot live half slave and half free. And that is not largely for normative, but for practical reasons. I think it is simply not practically possible to have two such very different systems working. Now, one of the other things that I said at the time that I will renew now is that it seems to me that was a meeting confined to gay rights. Now we've broadened it to the sexual agenda more generally. I think it is misguided to think that same-sex marriage is one of the only things that religious people object to. And unless and until a proposal for compromise takes into account all of the different things that religious people might have serious objections to, it doesn't have much traction. And I, at that point, cited just the docket of one of my colleagues, Frank Easterbrook, who had to deal with Baptist police officers who wanted not to police gambling casinos, and Catholic police officers who didn't want to police anti-war or pro-war movements. My favorite example of a failed accommodation is that of the Minnesota cab drivers who did not want to transport from the airport passengers carrying duty-free liquor. And the initial response of the city of Minneapolis, the overwhelming majority of these cabbies, I'm told, are Somali Muslims, was let's accommodate them. Let's have them have little lights, whether we carry or not carry. 5,000 refusals, including people dumped on the side of the road. And suddenly the city went from ready accommodation to first refusal will yank your license for 30 days, and I'm going to get the facts slightly wrong. Third refusal, you're out of a job as a cab driver. There are just too many different things that different religious groups can object to. And so I come back to the proposition that Smith was rightly decided for the same reason that Reynolds was correctly decided. That is to say, we cannot have the religious be laws unto themselves. I have been very worried about RFRA from the moment it was passed along these lines. And now aspects of RFRA have been constitutionalized in Hosanna Tabor, which terrifies me as few other decisions do. Those who know me will know Jesperson is another decision that Jesperson made me cry and Hosanna Tabor made me tremble, right? I think of Hosanna Tabor as citizens of the city of God united. And I think of Roberts as someone playing a long game, who has planted a seed and knows what the great tree is going to grow into. And it's a unanimous opinion because I don't know that anybody else quite saw what that tree could possibly be. So there are practical considerations having nothing to do with my own political normative commitments, which are said to feminist fundamentalism, by which I mean a commitment to the equality of the sexes as strong as and as incapable of being compromised as the commitment of some religious believers to, for example, not facilitating abortion. I have previously argued that this feminist fundamentalism is a commitment of the United States now under its current constitutional law, in the same way as a commitment to Islam is the commitment of certain other constitutional orders around the world. But I'll focus on my personal feminist fundamentalist commitments and say one of the things that gets discussed, I think, too little is the conscience rights of people who do not have religious bases for conscience. There are certain areas where they are protected. I love the Church Amendment, and I have previously bored some of the people in the audience by saying, here is what I would say about the Church Amendment. If I were an OBGYN, I would decline to facilitate the reproduction of a quiverful family, an FLDS family, a niqabi who came in with her husband who did all the talking for them, because I have a strong belief that no child at all, but especially not a female child, should be born into such a family. And I don't know that that kind of conscience accommodation is widely available outside of the Church Amendment. And I think part of the problem here, and I'll take a different angle on symmetries and asymmetries than Kenji did, is since I'm the last speaker of the day, I'm going to be as outrageous as possible just to keep you all awake.
No, you're outrageous that way even when.
No, but I mean, as possible, right? I mean, I don't usually go to my limits. You may think I've gone to my limits, but. So here's what I would say about the religious. With respect to the sexual rights aspects of things. And again, I think one of the major problems is we are now, so what I feared, when we're talking just about gay rights, is I said, they've got a lot more problems with women's rights than with gay rights. And I would second, I said then what Louise Melling said yesterday. That is to say, what we think of as the settlement with respect to, for example, the Title VII, the Equal Pay Act claims concerning women, is radically up for being unsettled. And to all of the people who have said no one would think of doing this, no one would think of banning contraception, I will say to you I'm a comparativist. Talk to the women of Afghanistan. Look at what the photographs of them from the 30s and the photographs of them today, and that's not choice, that's law. Talk to the women of Turkey, talk to the women of Israel. Hebrew U has just opened segregated classes for men and women. And the thing about religious accommodation, which is true in many religions as a matter of religious principle, is the more you asymptotically approach perfection, and the more you get, the more reasonably you demand of yourself and then also of the state. So I will say about the religious, they want to have their cake, eat it too, and shove it down my throat. And here's what I mean by that. I think if they could change the law, Doug is right that they still would. But there's also an asymmetry on the live and let live. I'm hearing a lot from Hosanna Tabor on down about a space for the religious where they can fully live their view of things. I don't see where there is such a space for people like me. Even let's focus on the people who agree with me on the sexual rights issues, because the religious are not backing off from the settlement that says there's no religious discrimination in public accommodations, in employment, and so on. At the meeting with Andy and George's proposal, there was discussion of cases like the Peterson case, where he was fired in a state where there is absolutely no protection for gay people because he wouldn't take down signs in the workplace. His company said, you can have them in your car, you can publish them in the newspaper, that quoted the line of scripture that said, man lies with mankind, he shall be killed, right? So the notion that, that it should be problematic not to say of your fellow employees they should be killed. So one of the things the religious are not giving up is the non-discrimination against religion laws. The other thing the religious are not giving up is the claim on subsidies, which has increased since in the last several years. I'll cite Hein Freedom Against Religion. I will cite the voucher cases. And the non-discrimination claims of the religious, for example, in the Christian legal situation, were not just leave us alone, but subsidize us equally, and we're not going to give up these subsidies. So I don't see I haven't seen on the table a proposal for living and let living that gives the likes of me the kind of safe space in which to live that the religious not only have claimed for themselves, but have more readily achieved for themselves than what I think of as my side. I'll also say that these claims that there have been no problem, there haven't been a lot of cases, there haven't been a lot of refusals. One of the practical questions I have is how we test whether a service is readily available. What kind of evidence at what point in time? Is this going to be like riparian rights, first in time, first in right? Or is it the opposite? Is it, that only the second person can object because the first person has to be there to provide the service? What are the empirics of this? I just have no idea. The other thing that religious seem to be suggesting is that what they do should be costless. I want to bring another case into the discussion that I don't hear much in this discussion. It's a case from the middle of the last century. It's Hamilton versus the Regents of the University of California, in which Brandeis Cardozo, excuse me, forgive me. People will say that just like people confuse O'Connor and Ginsburg, I'm confusing the two Jews. But anyway, Cardozo says, with respect to a religious exemption accommodation claim for a required course in military science and tactics to students at the University of California, denied. But the concurrence, Cardozo says, if petitions elect to resort to an institution for higher learning maintained with the state's money, then and only then are they commanded to follow courses of instruction believed by the state to be vital for its welfare, might be condemned by some as unwise, illiberal, or unfair when there is violence to conscientious scruples, either religious or merely ethical. More must be shown to set the ordinance at naught. Never in our history has the notion been accepted, or even if it's believed advanced, that acts thus indirectly related to service in the camp and field are so tied to the practice of religion as to be exempt in law and morals for regulation by the state. Different doctrine carries to lengths not yet dreamed of. Conscientious objectors might refuse this, that, and the other thing. The right of private judgment has never yet been so exalted above the powers and compulsions of the agents of government. One who is a martyr to principle, which may turn out in the end to be a delusion or an error, does not prove by his martyrdom that he is kept within the law. And I want to renew the notion that martyrdom, and I am willing to be a martyr for my feminist fundamentalist principles, or at least the bearing of costs, is something that the religious ought to rethink and re-embrace.
No more water.
Well, we have 20 minutes left of our original 80, and I've offered the panel, members of the panel, a few minutes each if they would like to respond to other remarks made by their fellows on the panel. So who would like to take a shot at that?
Well, the virtue of Mary Ann's remarks is that she doesn't hide the ball. There is no room for religious liberty in that vision. That part of the Constitution can just be deleted, probably keep the Establishment Clause. You know, I don't think that's what America is about. And the exemptions for religious conscience start in the 17th century. They start in the Carolina colony in 1669. We exempted Quakers from military service in the Revolution when national existence was at stake. We imposed some extra taxes on them. We made them contribute to the effort in other ways. We did not make them serve in person. There are early cases, of course, that go both ways. The early exemptions were mostly legislative. But if this is in fact a situation where no compromise is possible and the other side simply has to be wiped out, well, I don't want to be part of that project. I don't want to wipe out either side. I think one side will fade away over time, but how they fade away, it makes a huge difference. And stamping them out by force of law is not consistent with any vision of constitutional liberty. But that's what the agenda is here. Mary Ann makes it explicit. The rest of you make it implicit.
So,
Do you want to respond to that before I?
no, I'll
You know. So one of the reasons why I think this conference is so important and so good is that civil rights includes the right of religious liberty, and civil rights includes the right not to have sex be taken into account against you. And it was interesting because one of the things that I saw that I wrote in that 2002 article was saying race was maybe sui generis. And so I was being more sympathetic to the religious organizations in getting accommodations based on disability, sexual orientation, but I agreed with Bob Jones. And I think now, I'm not sure we can do that. And I think I'm partly effective. I just finished reading Alice Kessler Harris's phenomenal book about men, women, and economic citizenship, and how long it took first for the EEOC and then the courts to really treat gender discrimination like race discrimination. I mean, there's not, and when I said I was affected by Louis, am I saying your first name right? Louise's comments last night was, I think there are costs to a society when we make that distinction. So if race is not going to be sui generis, and in fact, we need to think about race, sex, religion, and again, I'm just including sexual orientation, gender identity, and sex, then I think we really need to struggle with 702 of Title VII. I mean, just in the employment context, which is carving out this space for religious organizations. And so again, I don't see a way as a practical matter for accommodating individual religious people when in fact it's going to hurt the dignitary harms of someone trying to come for service. I do think if you have a situation under undue hardship, which includes effect on customers, if you can in fact set it up that they get the service from someone else, they never know there's a difference, and you can actually accommodate the person. Again, it seems to me I actually would like to value that religious liberty that's included in saying you can't discriminate based on religion. I mean, I don't think that religion should be treated differently from race and sex. On the other hand, if in fact it's not possible, it is in fact an undue hardship, or if you ended up with a sort of RFRA type argument, that it's a burden, and then your response is, well, but I'm sorry, it's a compelling interest and there's no more narrowly tailored way to do this, then I think, yeah, there is a cost to being religious in a society where the social moral norms have moved on from where you are. There is a cost. And it might be that yours wanted to be a therapist, you just were dying to be a therapist, but you know what? Maybe you're not going to be able to be a therapist unless, and now this comes to the question of pluralism. What was the adjective you used, the person before pluralism? Confident pluralism. This is what I think we have to struggle with now, because there's a piece of me that says, let that group have its own religious organization that teaches, that does the therapy, and then let that person be a therapist just for other, evangelical Christians or Orthodox Jews or whatever, because I have this vision that pluralism requires that safe space for religious entities that are not holding the same moral views. So again, it's the difference between those individual accommodations, I think very difficult, and that's why I don't see the possibility. But what can we do in terms of the religious organizations? But I will tell you, it was just last night, Doug, partly because of asking the question to Mike McConnell of, well, how would you decide if someone is a good Christian? Like, is it just because they're, so they're in a same-sex relationship, so that's not a good Christian, but what about, do you have to then say, well, what about the guys who are having premarital sex? And McConnell went back with, well, it's the sincerity of the belief. And I was like, no, wait a second. And then when I go back to the statute, there's nothing about sincerity of belief in that exemption. The exemption is you get to hire people of your own religion. But, and here I think is the question, and this is why I think Hosanna Tabor is not the way McConnell described it yesterday? Oh yeah, as this, well anyway, however, it is true that Hosanna Tabor simply reaffirmed the ministerial exception that had been seen by other courts and that EOC had included in its guidance, but query whether the 702 exception that does not include anything about religious tenets. And I will tell you, in our EOC guidance, we say, a religious organization is not permitted to deny fringe benefits to married women, but not to married men by asserting a religiously based view that only men can be head of a household, okay? But is there going to end up being some pressure either for the agency to interpret 702, that exception, more broadly, because it would otherwise cause a constitutional problem, or a court ending up expanding that beyond what would be the right approach? And so again, I think that is the point of these types of conversations, to see where, and it's sort of what Martha Minow said last night, is there some way of finding that way of confident pluralism that will work? And I don't know, but I'll still show up to another conference and keep working, and I'm sure I might show up at the EOC at some point. That was a long answer, I'm sorry.
Okay, I guess we'll go in order. Just very briefly, I thought I might just say a bit about Marianne's comment at the end of her remarks about how religious people need to be willing to bear the cost of being able to live their religion, including martyrdom if necessary. And I think that makes a really good point. And in fact, I think I hear a lot more talk in religious circles about martyrdom than I used to. And this is even sort of happy news for a certain kind of religionist, who thinks that religion's gotten way too flabby by having good situations and good conditions, and it would be purer and stronger if we faced more martyrdom. I think Richard Newhouse used to describe this as the back to the catacombs attitude or something, that religion was a lot better in those days. Maybe, and it may come to that. I do think that, and here maybe I'm agreeing with Doug's comment, that though a lot of what has made this country what it is has been that it's been able to try and create conditions in which that hasn't been necessary. And if that becomes necessary, I also think that it's not only religious people who will suffer, but a lot of our other institutions, processes, and so forth that have depended and still do depend to a very great extent on the support of churches, religious people, and so forth will suffer as well. So I just want to say that.
So,
Take the mic.
so I think if Doug and I had more time to sit together and I was not trying to be brief and outrageous for the precise purpose of starting a conversation, he might be less disturbed by, he'd still be disturbed, but less. So one of the things I want to say is that the United States has been very lucky in that for its first several hundred years, several hundred years of settlement, the religious disagreements were about what to believe and how to worship, and not about how to live in society. And it is a lot easier to, I don't want to eliminate free exercise, but the free exercise, the original free exercise, the original need for free exercise was less about how to live in society. And the first time there was a major disagreement among religions about how to live in society, I turn to my Mormon neighbor and say, that claim for diversity, that claim for free exercise was squashed flat. And the practical problem now is that we are trying to move from a world in which the disagreements were how to believe and how to worship to a world in which the disagreements are about how to live, and a world in which we're living in a much more interconnected way than we were before. And I note that, so martyrdom is simply costs or absorption of some costs. And I note that, when Doug said that the Quakers were exempted and they had to pay an extra tax, right? So I think that the military exemption for Quakers are in all kinds of ways distinguishable from a lot of the potential claims for exemptions available now. And I will say also about Hosanna Tabor that if you are in favor of religious freedom, you should be disturbed by the privileging of a ministerial exception from a sacramental exception, right? So when in Hosanna Tabor they try to distinguish Smith, they say, Smith involved government regulation of only outward physical acts. This concerns government interference with an internal church decision that affects the faith and mission of the church itself. Well, I had 13 years of Catholic education. I was taught to call only outward physical acts sacraments, which is exactly what the Smith claim was. So, even from the perspective of a proponent of robust religious faith and exercise, the practical problems are insurmountable.
Questions? Oh, many questions.
And let's take like 3. I really like that.
Okay. This is actually a suggestion for Hai. Hai, you expressed 2 ideas that you indicated are both really important to you, and you also expressed your sense that there's a conflict between them. One of the ideas is your discomfort with rejecting the existence of burdens on religion that are real and it's substantial from the point of view of the believer. But you also expressed discomfort with the judicial practice of inquiring into the existing, worries about what happens when judges are given the task of deciding whether burdens exist and whether they're substantial. And I want to suggest that it may be the case that with respect to certain types of burdens, that there's the possibility of reconciling those 2 desiderata. Namely, if it is the case, with respect to a particular class of burdens, that it always correlates to state interests, that always override the religious right involved in that kind of case, then it follows that not only is it not necessary to engage in a case-by-case judicial evaluation of the burdens, but that in fact, a case-by-case approach should be, instead of a case-by-case approach, what's appropriate in that class of cases is a threshold rule, an a priori rule, a categorical rule that says whenever someone asserts a right to an exemption from that type of obligation, we know a priori that you're going to lose. Now, maybe saying that business corporations aren't persons with free exercise rights is a good proxy for that, or maybe drawing the line between commercial and non-commercial. I've suggested, I believe you can make this case with respect to financial obligations and claims about financial complicity. Haven't made that case out loud yet. But if you can, then I think that's a class of cases where you can have a categorical approach that does not involve denying the existence of the burden. You can recognize the existence of the burden, And it gets the courts out of the business of a case-by-case assessment of the burden. So that's the case where you can have both of those things.
Yeah, yeah, no. No, can we do like 3 comments?
We can.
Just, or do you, right, we're smart enough to take notes, right?
Choose the ones you want.
Yeah, go ahead.
I'm afraid this might be the kind of question where you speak and then put question mark at the end, but I'm going to try it. So I took from Doug's observations the notion that Marianne had made explicit what was otherwise implicit, namely that it was an either-or proposition. And I both want to, I don't know if that's a correct reading of what Marianne's saying, but I want to distinguish myself from whatever impliedly that suggested, since you invoked yourself as having disagreed utterly and completely with almost everything else that I had said. And I want to start by saying Michael Helfand and I go back some ways, and I highly admired his conclusion of his talk, where he was puzzling about where he would come out and sort of exposing something that he was wrestling with. And I want to say, in case it wasn't intelligible to you, I am both still puzzling with this and also was trying to put out something that was trying to be a coordination and not one side swamps out. And I don't know that it was audible. And so I just want to at least put it out there. And in this respect, I'm going to in part affiliate myself to something that Marianne was saying. And that is that the concerns that Doug and I were articulating did not run to the idea of any religious accommodation claim was itself problematic. We went to enormous pains to try to show differences in structure between the earlier set of claims that are at the site or the heart of the constitutional tradition and some of subsequent kinds of claims. And a feature that we were trying to emphasize in these remarks of the subsequent claims, which is relevant to the question of whether there's an effort to coordinate or be moderate in anything that was said, goes to the idea that they're based on complicity. Now, what's salient about the complicity point? It's not just a tag. The complicity point is, and this is the crucial thing for which I'd like the panel to respond, there's structures of claims where the claimant is saying, my religion leads me to want to, I judge what you're doing by my standards, and I judge that wrongful. So the claim at root, the belief structure, is normatively imperial and non-pluralist. It's saying, actually, there's one right answer, and you're wrongdoing in my view because you don't do what I believe is right. Okay, is the question then, okay?
Yeah.
Okay, is it intelligible to try to treat separately those sets of questions which are, as Marianne said, about living in society with others who don't share your views?
Right. Okay, let's do one more and then let's answer.
Professor,
More, and then we'll let the panel take a shot.
Professor Laycock, you said that the bishops hold a deeply anomalous belief that contraception shouldn't be used, but also that the religious institutions should win their cases. And my question is whether it makes sense to attribute the beliefs of the bishops to these religious institutions as opposed to, for example, the nuns and theologians that they've been cracking down on from off campus. Shouldn't the belief be that of the community as opposed to the bishops?
All right, who wants to take a crack at one, 2, or 3 of those questions here in our last couple of minutes? Across the panel, and then we're done.
Okay. So 15 minutes is very short. Obviously, Doug and Riva said there's a whole set of claims that don't trouble third-party rights, and they support those, and I didn't mean to deny that. I appreciate that. But I did hear you say we can't grant these claims of big religions because they're just perpetuating their movement, and the movement has to be stamped out. Complicity theory is not inconsistent with pluralism, right? It's part of a mobilization. What was that all about, right? Giving exemptions, these people helps them mobilize their movement, and we got to defeat the movement, so we can't grant exemptions?
I didn't say those words, but...
Okay, well, 15 minutes is short for you as well as for me, and so... Yeah, it's easy to see how we misunderstood each other.
At dinner, you can answer.
Right. So So the complicity theory doesn't say the other person can't do whatever they want to do, right? The complicity theory says, I'm not going to help you do it. I'm not going to help you do it. Hobby Lobby doesn't tell their employees what they can do with their wages, what they can do with their own money, with their own time. It says, we're not going to arrange for it, contract for it, and pay for it. And very briefly, and the bishops, this is not the salient issue it used to be, but in the Reformation, people fought and died and went to the stake over forms of church governance. They matter. They have theological reasons behind them. The Catholic institutions are run by the bishops. We may not like it. A lot of Catholics don't like it, but that's the way it is. The bishops speak for the church.
So I think it is really important to note that not all religious accommodation requests are the same, and that what we heard is it's a lot easier when you're dealing with accommodations around dress or worship. That was Kenji's point. That was a number of points of that's how the law developed. Now we are in a situation because of the shifting moral norms, although for women it's been, for some time. And therefore, we are in this situation of the complicity things, and I'm using my religious beliefs to say what you are doing is wrong, okay? I think given that, we definitely need to distinguish between individuals and institutions in terms of the pluralism issues. I take Nomi's suggestion as a very good one, that now as we think through, it might be that we can say just ahead of time, we're just going to tell you certain things will be an undue hardship. And that's it. In this, I really do think it's like the definition of disability. I don't want to get hung up about whether you really do have a disability or not. I want to see whether you were, qualified for the job, and a reasonable accommodation could have helped. I don't want to get hung up on whether I think it's really a burden. So that my difference is I think everyone should be involved on the front end in terms of sincerity. Okay, but then it's like completely almost hands off. I don't want to get hung up. And now let me just see, is it an undue hardship? If it's Title VII, and again, is a compelling interest. And if we can, in fact, create some rules, I thought yours around financial stuff was very interesting. That's what we should start doing. But I do not, but I don't, I think that's all I wanted to say.
Yes, that microphone.
Okay, so I just want to make clear what I think is not possible, leaving aside whether it's desirable or not. First, I think that, Reynolds and Smith had it right. We cannot categorically, as a matter of right, whether that's constitutional right or, frankly, statutory right under RFRA, accommodate every religious desire to be exempt from every generally applicable law. And choosing which religious desires to be exempt from generally applicable law on a basis other than how easy it is becomes potentially an establishment clause problem because it privileges some religions over others. Then the other thing that I think is not possible, you can persuade me otherwise, in both of these cases, these are descriptive claims, not normative ones. It seems to me descriptively not possible to settle the sex wars, which I describe as wars about how to live in society, because, so what I said, at Princeton a couple of years ago is, take the public schools. It is possible not to discuss certain things, even evolution, it is possible not to discuss in an education. I don't think it's desirable, but it's possible. It is simply not possible not to discuss family, sex, and gender in the course of 12 years of education. Most of literature, most of sociology, much of world history, biology is going to be concerned with these things. And if you have a world in which one side says any mention of ways of organizing one's family, sex, and gender life that are not the ones my religion favors is impermissible to me, and another side says the absence of any mention of the kinds of things that I favor, for example, same-sex relationships, is discrimination to me, you have an unworkable situation. And I don't know how, again, purely as a descriptive, pragmatic matter, I don't know how you compromise on that. Even assume, so whether or not you want to is a separate question, but I don't think you can.
Professor Smith, you'd like the last word? You have it. You have the last word.
Well, I guess. I was just going to say something very briefly about this complicity issue that's been brought up again. When I listened to Reva and Doug's presentation, I thought as a description of the structure of a complicity claim, they were almost surely right. It didn't even take much work, I think, to really show that. That, of course, that's what complicity objections are about. And if someone else is doing something that someone regards as wrong or sinful, if they put that kind of religious terminology on it, and they don't want to help with it. The normative conclusion, though, struck me as really kind of odd. It seemed like you thought that because this involved a judgment that what someone else is doing is sinful or wrong, that makes this especially problematic in a pluralistic society. I would have thought just the opposite conclusion would follow. All of us are going to judge some things that other people believe or do, certain practices and positions to be wrong. That maybe the use of contraceptions for some people, for other people it's what they regard as bigotry or something. They're going to regard things as wrong. If we're going to be able to live together, we, I think, need to explore ways in which people can hold views that other people think is wrong without being complicit in other people's wrongs. So I would think that, if anything, that would support just the opposite normative position from the one that I understood you to be taking.
Yeah, I think the panel kept you not just looking alive, but being alive.
Yeah.